So this has been reported that he has filed an appeal, which is strictly speaking not correct. He has not filed an appeal. He's filed a request for permission to appeal because he cannot appeal as a matter of right. You can appeal as a matter of right once your case is over, which of course in the criminal context is once you're convicted. That's when you can appeal, and you do have the right to appeal at that point as a matter of right. If you want to appeal while the case is ongoing, that's called an interlocutory appeal, and those are obviously limited. There are some situations in which they're permitted, but for the vast majority of situations, they are not permitted. And you can ask for permission beyond those, but of course, it's discretionary. It's not as a matter of right. So let's talk about generally why these would be granted. Why would you grant an interlocutory appeal? Why would you do it? Well, first of all, we can say why you wouldn't do it, right? You wouldn't do it because the alternative would be we grant review on every single decision from the judge. The judge makes decisions all the time about what witnesses can testify. There's an objection to a question, right? The judge says sustained, he says overruled, right? That's a decision. He allows the witness to testify, cuts off a witness, he changes things around, he grants this petition or he doesn't grant that petition, right? So trial judges make lots of decisions, lots and lots and lots and lots of decisions. So if we allow people to appeal all those individual decisions as a matter of right, we would never get anywhere. We would simply never get anywhere. You're talking about hundreds of decisions for each case, and every single one of them has to go up to the Court of Appeals and back again. And before we can move on, we'd never get anywhere. So that's why we wouldn't do it, because it would just be completely judicially inefficient. So why do we do it? Why do we allow it? Well, there are certain circumstances which we do allow it. So I'll give you some of the hallmarks for why that would occur. One is it's a matter of extraordinary importance. This is a case that involves some sort of issue that has extraordinary implications. For example, when Trump was being prosecuted, whether or not he had immunity, for example, would fall into this kind of category. It's an extraordinary thing, right? Whether or not the president can be prosecuted or not is a question that's obviously a novel question at the time, and a question that's of such great importance that it would counsel for a more immediate review. So this sort of extraordinary, over the top, issue. Another reason that you might allow an appeal is if it's a truly novel question of law, although not even then necessarily, because then those issues can just be resolved by the Court of Appeals. But if it's a truly novel issue of law, you might allow for an appeal before the case is over. This, for example, happened with the Crumbley's parents' case, the school shooter's parents, where they were being prosecuted for manslaughter. And although that would have been available for a review after the case was over, this is kind of that sort of territory, right? It's a completely novel question at that point. Can the Crumbley parents be held criminally liable for this thing? And so in that situation, the Court of Appeals did allow that review to resolve that novel question. So that's another situation where it's possible. Another situation where it's possible is if there would be no effective mechanism for the appeal after the appeal. Like, it just doesn't work. The Court of Appeals can't redress the harm. So something is happening the Court of Appeals can't fix. A classic example for that would be double jeopardy. So suppose your defense is double jeopardy. I've already been tried for this crime. Okay? Well, if we didn't allow you to appeal that issue, and the trial judge says no. The trial judge says no, it's not double jeopardy. Well, if we didn't allow you to appeal that issue, there would be no effective mechanism for review because the trial already happened. That's the problem, right? The entire defense is, in this situation, I have the right not to be tried because there's a double jeopardy problem. I have an absolute immunity against a new trial. And if we didn't allow you to appeal until the end of the trial, the very thing that you have the immunity for will have already happened. So there's no effective mechanism for review. So that would be a situation where the Court of Appeals would grant review because there is no effective mechanism for review. And that would be a situation. And the other situation where it would happen is where the court is exercising its supervisory authority. So in this situation, to put in layman's language, it's because the Court of Appeals really wants to smack the lower court around. They're really pissed. The court below has fucked up so hard They just really, really want the opportunity to slap the court around. And at this point, it's no longer really about your case. You're now just an effective mechanism for them to do what they really want to do, which is slap the court around. So at this point, you're not really there. You're just a convenient excuse the Court of Appeals is using to, beat up on the court below because they want to destroy their day. So those are some of the situations that you could potentially have an interlocutory appeal. And as I think you would appreciate, none of those situations happen here. This is just bog standard. So the thing is, he won't get his petition because this is a completely normal, completely bog standard, completely ordinary motion and a completely bog standard, ordinary decision by the court. All right, it's a day that ends in Y. It's not extraordinary. It's not novel. It's not, there is an effective means of review, because if the Franks motion, we can dismiss the case, the Court of Appeals would dismiss the case. That would be an effective means of review. And, there's no indication that the Court of Appeals is just looking for an excuse to beat around the trial court because they feel like it. So none of those sort of standards apply. So I'm fairly strongly confident the Court of Appeals will deny it, and deny it rather summarily. They get these things all the time. They have already a lot of things to do. The Court of Appeals is already busy with all the other things they have to do with their time. They simply don't have time for your bullshit. And so, go to court, have your trial, and if you're convicted, then, let us know all about it, and we'll let you know how it works out for you. Probably not well, but we'll let you know eventually, but not now. So that's the thing. All right, so this motion this will be denied. There is a lower chance of this being granted than the underlying Franks motion being granted. That's how bad his odds are. There's a lower chance of this being granted than the underlying Franks motion, because this is just a bog standard day. It's a day that ends in Y. The Court of Appeals has better things to do. They can't be bothered with you. Not now, maybe later. We'll talk. All right, so that's that. And then, of course, we can also, as a result of this, conclude that Nick Rekieta has not struck a plea deal. Because if he had struck a plea deal, his plea deal would almost certainly require him to give up his rights of appeal, because that's a pretty standard provision in a plea deal, right? There are sometimes some exceptions to that. Sometimes people do preserve the option to an appeal in a particular issue, and sometimes they actually win despite that, which is odd. But 99.9% of plea deals, you give up all your rights of appeal because, that's, you're just pleading guilty. So you're confessing to the crime. So, so we can infer that there is no plea deal. There has been no plea agreement, because if there were, he wouldn't be filing this. He would be barred from filing this.